Good evening, everyone. Thank you so much for joining us today and giving us your valuable time. We have planned this session in a fruitful way so that in a crisp and well informed, so that all the attendees today can sleep today a little wiser. So my name is 𝗖𝗎𝗃𝗃 and I'm an internet law seeker. And today we have with ourselves Mr. Akash Trikha. He's the assistant professor at 𝗖𝗎𝗩𝗜𝗃 Anushan, sorry sir, Anushandhan National Institute of Law, Odisha, Bhubaneswar. I'm sorry for my pronunciation. I'm a little tongue tied, but thank you so much, sir, for giving us your valuable time and coming us here. Before that, I would also like to tell you that sir has extensive experience and knowledge in the field of contract law and competition law. Thank you, sir, once again for coming here and giving us your valuable time.
Yes, thank you so much, 𝗖𝗎𝗃, for the introduction. Are we now ready to begin the session? All the participants have joined?
Yeah, sir.
Okay, okay. Yes, so today we had with us the topic in hand for the discussion, that is the COVID-19 and the impact that we all had faced and how the competition law has been impacted. Is my audio clear to everyone, 𝗖𝗎𝗃?
Yes, sir. It is.
Okay, okay. So today, like we all know, we are again in the month of March, and the previous year in the month of March, all the disaster and catastrophic thing that has happened, that was the virus, that is COVID-19, and it has severely impacted the not only India but all the nations across, and the economy has been like been to a standstill. So it is really important for all of us now that we get back in our ordinary terms, but we are very much facing difficulty in getting back to our what was so-called our normal. Now wearing of the mask has become the new normal for everyone, and getting the sanitized hands and getting sanitizers in our hands, in our pockets, in our wallets, in our bags has become a new normal for everyone. So these times are not usual times that we had seen or have witnessed. These are the unusual times, and in these unusual times we also require certain unusual measures that needs to be taken. So during this pandemic, one thing that we all have seen that is that everything can be now done digitally. Prior to that, digitalization was not one thing which we were focusing on. Everything was with the physical verification, physical mode and everything. But this thing has taught us that yes, everything can be done through the use of internet, through the use of online medium. So there's a rampant increase in the various platforms that are being used for imparting of education for each and everything. Similarly, no exception is the era or is the world of competition law. Here, there were certain provisions, certain guidelines which were issued by the Competition Commission of India, that is the CCI, that how during this time, how the mergers will be done or what were the guidelines issued. So number of guidelines were issued during the three guidelines that came out across these times, if I'm not wrong, with the dates. One was first at 30th of March, the second was somewhere around 14th of April, and then 19th of April. So these were the three dates where the guidelines were issued by the Competition Commission of India regarding what and how the conduct will be. So when we talk about the competition law, first of all, let's discuss just the very basic. What is the competition law? If we come across the word competition, then what we understand from the word competition. So if we generally talk about the competition, it is something that we all know that yes, there will be a competition. We live in such times where we are accustomed to all the competitions. Here also the word competition, which has been which is to be used in the context of the Competition Act of 2002, means that any of the company, we can say, or any of the company or any of the industry whichever has been in the force is trying to compete with the other so-called entity or the enterprise which is present in the same environment. But these kind of competition should not be against the economy. It should not be something that will have an adverse effect on the nature of the competition. So always the healthy competition is being promoted. And if we just talk about the definition, or we can talk about a very single liner definition from a common man's point of view, that means that in every competition there must be an element of healthy competition. When we are focusing on the Competition Act, when we are focusing on the Competition Act of India, along with all the amendments that have taken place, along with whatever things that have taken place with the due course of time, here the one thing that the CCI always tries to maintain is a very balance between what a caution can be and what is the proactive role of the market competitors. So both the things are played a very important part, or an important role, we can say. That means the CCI manages or balances the act. What kind of act? The act of the competitors as well as the act of the other players in the market. Because if there is no other competitor in the market, then it will turn to be a monopolistic market. Here, because we are consumers of many product, we intake a lot of things. Here we need to have a very good amount of balance for that. So for that reason, the Competition Act was enacted in India from the era of 2002, or from the year of 2002. Before that, we had the MRTP Act. After that only we had entered into this Competition Act, because there were certain lacunas in the MRTP Act which were overcome by this Competition Act of 2002. And if I talk more specifically, this act was in true sense enforceable from the era of 2009, because after 2009 we have seen that there is a rampant increase in the use of this competition law and all other things. Now, if we talk about how this competition law has impacted the time of the pandemic, now we have come across the terms called lockdown. Clear? So, if I interpret the term lockdown, there has two interpretations to it. That is lockdown and lockout. Now, lockdown was because of the pandemic, that we all were forced to stay in our homes because it was necessary. Advisories were issued by the government of India to do so. So that was something lockdown. Now, what is the now we have come out from the phase of lockdown, and we are moving toward the phase of lockout. That means now we are moving out from the phase. But what are the challenges? Economic revival is the biggest challenge for every one of us, because economic revival is depending upon the very factors of the country, and all the country are now facing hard times how to recover their economy, because we have been in a situation of recession, as if there were so much everything at was in halt at the time of the pandemic for say 9 months, if we take into consideration. Yes, online practices were being done, but it takes very different approach when we are trying to revive the economy, and if we are trying to talk about the marketplace and the situation. Now, if we talk about the market scenario, the markets have completely been dampened. They don't there were such a huge difficulty at the time when these situation has occurred, that the small firms, the small business entities, they were forced to close down. They don't had any option left with them. Along with that, what other things had taken into the aspect of the competition is that we have seen that over the night, only, the prices of the essential commodities, until and unless the Essential Commodities Act was implemented, the price of the N95 marks, the price of the sanitizers, they had so much where they were in so much of demand, and the prices were like skyrocketing at that point of time. Any particular mask that we used to take from the chemist shops were costing somewhere around 100, but because of the panic buying, because of the situation that had made it that mask per se was costing to us for rupees 500. Each particular mask, we had situations that the chemist have charged us with rupees 500 or somewhere between 300 to 500. Sanitizers, 10 ml, 20 ml, 40 ml sanitizers bottles that were available in the markets, they were in such a huge demand that the price again went from some 50-60 rupees to some 200 and 250 rupees. So this is how the impact had been seen. But again, the competition commission and the competition advisory boards had entered themselves into this kind of situation. They never had stepped down. They were with the people of India. They had at that point of time regulated these all things. How? Because they were included under the essential commodities, and the government of India had now the power to regulate such kind of things. So now the producers, those who were, or the suppliers, those who were charging such an exorbitant price, now they cannot do so now, because it has been included in one of the aspects of the essential commodities. So the availability, the distribution, the supply has to be seen along with all the aspects. And here also, when we talk about competition act, the only thing that we talk about is how to regulate the distribution, the supply, the other various factors that are relevant in the market scenario. If we talk about the sections 3, section 4, section 5 and 6 of the Competition Act, these are the important provisions where the crux of the Competition Act can be seen, because section 3 provides for prohibition of the anti-competitive agreements. How these anti-competitive agreements can be prohibited, that's a very different, altogether a different scenario. Now there is abuse of the dominant position, and there are certain things that have been related to the at the times of the anti-competitive agreements. That means these agreements which are to be very unfair in nature, that can be some discriminatory in nature, they can relate to some price fixing, or they can relate to any other factors. So they are to be taken into consideration to be the anti-competitive agreement. And if we go into the details of this anti-competitive agreement, we will come across various terms that have been used in the Competition Act, that is the horizontal agreements and the vertical agreements. Here, if we talk about the aspect of the scenario, how it has impacted, now we can see that over the night, how the prices have changed, over the night, how the commodities were taken to be from not so essential to be included in the essential commodities. Now, if we also talk about the companies that have taken they have taken into consideration that yes, they will be merging themselves, or they would try to have certain things done at the time of this pandemic. That means they are trying to find a solution. How? By going into the research and development. They had tried to 2, 3, 4 companies, or any one huge company and the other company which is not having its existence in the market, they had tried to come together in these times, and they had tried to collaborate. Now, what will be the impact by this? We can see that there can be difference, there can be any activity that they have come across is for the research and development. Now, what kind of research and development at these times? Supposedly they can go for the formation of a COVID vaccine, or for the research and development of that vaccine, or they could have given their time toward the production of the kits, for the testing kits that were made. All these things they could have done along with them. And this is when the large companies try to overtake the smaller enterprises. Now, these kind of things were allowed by the Competition Commission of India, but again, there were stipulations that if these kind of things are allowed, now the competing parties, that means the companies, those who were competitors at a point of time, now if they're allowed to merge, they will be having what? There will be a reduction in the spirit of competitiveness, again, which is not so good from the eyes of law, because in the market, the competition, the equilibrium between the competition has to be maintained, and CCI works as a watchdog for that. So we can say that any kind of thing that has been allowed by the so-called Competition Commission of India at that point of time was because the situation wanted us to make so. If we take the prospect of the times when we are in, that means the Supreme Court has also taken the interference at the time of this kind of situation, because the Supreme Court was forced to entertain a PIL from which was filed by an NGO, an organization that is Justice for Rights Foundation, that yes, in these times there should be equitable distribution of whatever commodities are required, whatever the essential commodities are. So these were the instances where we come across that how the Competition Commission, how the various agencies had taken into consideration the the very aspect of the competition and the impact also. So every country has seen the impact, every country has faced the wrath of the COVID-19. It is not in just India who is having the problem. This problem is concerned with the world at large. All the other commissions, not only India, but the various other commissions like the European Union, they had a different commission for this. Then we have the American Federal Trust, they have their own regimes, how they had issued, what kind of notifications they had used, what were issued by them. They had a altogether a distinct list and distinct criteria of what could have been done or what is allowed and what is not allowed during these times. Now, if we remember that on the March 24th, the first national lockdown was imposed. And after that, the 21 days first ever lockdown was witnessed by not only India, but towards the in India, if we talk about that, the 24th March to 2020 was the day when it was announced that there will be a nationwide lockdown and it would continue for the next 21 days. So within that, nobody had idea what to be kept at hand, what all things to be accommodated, how and when to be made available. So again, the distribution, supply, and all other things needed to be integrated. So it was the Competition Commission of India who had issued the directions that yes, you need to do certain things at this point of time, what were allowed. Supposedly, if we take into consideration, there were the matters which were pending before the commission. Now, when there was a sudden implication of this lockdown scenario, so they were forced that now no new thing could be taken into consideration from a fresh point of view. So they had to delay it. Now the mergers, the regulations were delayed. They were given time for everything because there was scrutinies to be done. There were verifications to be done. There was point of view from the third person or some experts needed to be done. So it could not be possible because these were not the usual times, and because these were the unusual times, certain measures, certain drastic steps were required at that point of time. And the Competition Commission of India has successfully made out the various things at the time when such things were required. Now, some of the measures which were taken by the commission was that they had allowed electronic filing. They had made it that all the filings with relations to whatever matter that come before the commission with regards to Section 3 and Section 4 of the Competition Act could be filed online, or there was complete freedom which was given to them. And the filing submission proceedings were also kept at halt. If at all there is any emergency, if there is at all any immediate measure that requires to be seen, those could be filed. Those could be filed. Now, these were the steps that the Competition Commission of India had taken per se at the time of the COVID-19 pandemic. But this does not mean that the commission has only done that. The commission was very vigilant. It had always been visible, and we had also come across the times where the exploitative and unilateral conduct of the businesses were to be tracked and were to be punished. That means we cannot allow that, the commission cannot allow for exclusivity of the supply of the distribution. way. They cannot be the situation that you can tie certain things with the commodities, or you cannot tie up a particular thing with a essential commodity, or you cannot tie an unessential product with an essential product. These were the things that certain producers, certain distributors had tried to do at that point of time. They had tried to tie in certain things with the essential commodity, so that the consumer will be forced to take this along with the thing, or they would not sell it. So these regulations had to be checked, and this is the commission who can do with all the vigilant actions, and the commission has very successfully done all these things. Now in India there is the MRP, the maximum retail price, but there are places where the minimum retail price or certain things, certain anti-competitive agreements are being carried out. So the commission needs to be more vigilant. The commission needs to be more proactive in the role of taking care. And at these times, one thing that had come across with the, if we talk about the impact, is that at these times there are cartels. Now cartels are not new that competition law is facing. Now in these times there are certain crisis cartels. What are these crisis cartels? If we talk about, that means at these point of time, if a company is facing any loss, then they try to come up and they try to form an association within themselves, and they would try to regulate the structure. Now because the market is down, the economy is down, and the revival is very much difficult, and the prospective year, that is the 2021 that we are in, needs to be a year where investment is required. Various investments are required, not only from the Indian sectors, or not only from the Indian markets, but the foreign direct investment is very much required. Now if these crisis cartel exist, there will again be a anti-competitive agreement. There will be appreciable adverse effect on the competition of the India, and that is how it will take into consideration that this will have a very negative impact on our economy. So we must see that when I talk about we, that means the Competition Commission of India must be very much vigilant with regards to all the activities, and they should check what are the activities that are going on around and along with the other things that a competition commission does, because it has the work to maintain the balance. It is like a watchdog which has the responsibility and the role to do a lot many things. And if we talk about the international scenario, it's if we talk about UK, if we talk about the United States of America, they also had done various steps. They had taken into consideration the various steps. And if we talk about certain countries, Spain, which had seen the which had faced the wrath of this COVID-19, at that point of time, the commission of Spain had issued notification that everything has to be postponed till the emergency is not getting over, because at that point of time it was not possible for certain countries to involve themselves into the normal practices of the trade, of the distribution of the supply units. So the Federal Trade Commission and the US Department of Justice and the antitrust divisions have also issued various guidelines with regards to their own nations, and the Competition Commission of India has time and again issued various guidelines. uh, I would proceed again, but I would just ask, is there any questions, Ashwath, or should I proceed?
No, sir, not till now.
Okay, okay. So now if we talk about what kind of scenario the Competition Act is going to supply to us, we have talked about the exploitative practices. That means if we see that there are some collaborations are permitted, but these collaborations, whatever has been permitted, should not be out, or should not have any appreciable adverse effect on the competition of the India. So companies or the enterprises or the firms, they should try not to bundle or not to come into existence with any kind of clauses in their agreement which will adversely affect the competition of the India, which will be against the competition law of India. And if we talk about the anti-competitive agreement, it always relates to the Section 3 of the Competition Act. However, the supply, distribution, storage, and all other things has to be taken into consideration when we are talking about this. Now, what is required from the point of view is that in these times where we had seen how the economy is getting dampened, what can be done is there can be consideration, there can be some proactive measures that can be taken. That means staff should be made available whenever there is any urgent requirement, any kind of urgency is there. It could be taken into consideration that yes, the party should have ready with all the things that they need to. And if the parties ensure that they are trying, the enterprises are trying to go for the merger process, or they are trying to go for any other dealings, they should strictly adhere to the guidelines that have been issued by the Competition Commission of India. Now, certain competition authorities are taking very strong steps if the guidelines, if the protocols, whichever has been issued, are not adhered to. Now, the United States had issued one such advisory that any kind of the enterprise which are not strictly abiding the rules and regulations, then they would be getting the penalty. They will be facing the consequences with regards to that. So when we are talking about this proactive measures, these proactive roles here, the competition needs to be the competition should be healthy, the situation should be healthy. And because we are now in the phase of the lockout and not in the phase of the lockdown, various other things have to be taken into consideration. Now, at the time of the merger per se, the green channel regulations needs to be adhered to. Now, what are these green channel regulation? This, by an amendment in the year of 2019, around the month of August, this regulation was imposed, which had tried to make the things easier for the purpose of regulation, for the purpose of combination, or for any other sort of activities. These were certain regulations which were made for easing out the process. Now, if we talk about the scenario of the COVID-19 and the difficulties that had been undertaken, so various other things were seen, that is delays. The first thing was the delay, whether we talk about the online mode or we talk about the offline mode. This delay was very much persistent enough, and this is because the situation that not only India, but the European Union, the France, the Germany, Spain, and various other countries, they had faced a lot of problem in the time. Now, if we talk about certain regulations and whatever impact was seen from the situation, in the case of China, we had the state administration, and the market regulation, which had issued certain guidelines for COVID-19 pandemic. And if we talk about the European Union, in response to that, the Commission is encouraging the business that and the business houses that you should go for delay in the merger notification wherever it is possible, because there needs to be a lot of process needs to be done before the CCI or before the antitrust agency allow for going into the process of merger and the regulation. Now, if we talk about the perspective of the France, the French law had declared that the public emergency, the public health emergency, is one of the major concerns. And in the pandemic, in this kind of epidemic situation, whatever has been issued by the French authorities, by the government, it should have been adopted with regards to all the rules and regulations. So they had tried to give the nation a chance that yes, they will be doing it in phase wise, whether it is the work or whether it is the work of any other authority, they had carried out in phase manner, that is phase 1, phase 2 and phase 3. And in India also we had seen that when India had seen the scenario of opening up, it was not opened altogether. There were series of restrictions yet imposed on the persons how and when they are to be done. Now, if we talk about the United Kingdoms, so there was this guidelines from the continuing investigation of the mergers, and in trying to hold for whatever kind of reasons, it is encouraging that the merging parties should consider whether some filings can be postponed if the merger is not particularly well advanced and not ultimately proceeded, what could have impacted. So if the only thing that all the commissions had tried time and yet again is that if there is no such urgency, if the thing could have been postponed, you go for postponement or you go for delaying it, because only the urgent matters were to be heard. Now, what we could have done, what we could not have done in these times, that is also one of the factors that we can discuss during the impact of this kind of seminar. So what could have been done, that means during the COVID-19 scenario, what all things were allowed from the perspective of the Competition Act and from the perspective of the Competition Commission of India. That means we need to coordinate certain activities with regards to sharing of the data or with regards to any other activity that we are looking into. So whether it is a medical or a healthcare product, or whether it was with regards to the supply of the ventilators or the supply of the emergent materials such as the face mask, the vaccines, the gloves, all these should have been integrated, and they had been with the time integrated into the essential commodities. So the COVID-19 has provided that these coordination does not lead to the or should not impact in price fixing. So everyone has the right that they should get it. Now, what we had seen that in the supermarkets, in the malls, in wherever in the grocery stores, the they were out of stock, they were running completely out of stock. Why? Because of the panic buying, because the persons were trying to hoard up the commodities. They were trying to take the advantage out of the scenario, that they were not going to release those things until and unless they were paid some higher amount than the usual amount whatever they could have charged. The example that I gave, any commodity which would have costed you somewhere between 100 to 150 was at that point of time sold between 350 to 500 rupees. So this is because of the persons, those who are trying to take the advantage. But again, they need to adhere to the guidelines of the Competition Commission of India. If they aren't doing so, their strict penalty would be imposed on them, strict regulations were imposed on them. And if we talk about the medical supplies, supposedly at that point of time, we had come across various news that how the hospitals were running out, how there was no supply of the ventilators, the face covers, the face mask, the gloves, and all other things. So at that point of time, these things were to be included in the essential commodities, and they had been included at that point of time. And if we talk about the joint ventures, many companies or many enterprises have tried to enter into joint ventures to undertake the various things. That means they had been entrusted with certain things to fight against the coronavirus pandemic. So these joint ventures were helpful at that point of time, and at that point of time it was also seen that if they're allowing such kind of joint ventures from the point of view, then they should not have impacted the economy, they should not have impacted any adversity to the competition law. That means they should not have caused AAEC, that is the appreciable adverse effect on the competition law of India. So the joint ventures were allowed, but keeping into mind that they are in no way going to hamper the provisions which have been allowed. Then what was not allowed at that point of time? what was not allowed in the duration of the COVID-19? Any coordination with the competitors. That means in the market there needs to be a competitor, because if there is no competitor there won't be any competition, and because if there is no competition we won't check our activity. Now in order to have a growth in ourselves, we need to have an external mechanism who will be forcing us that we do better and better and better the days that come to us. So when there is a product in the market, in order that the market does not go into a monopoly, there needs to have another competitor in the market which will have which will have a similar kind of product. But if there are two competitors or three or four competitors in the market, then the abusingness will be less, the dominance will be very much negligible. Why? Because they will try that, yes, they will be trying to give at the fair prices, they will try that they will give the product at a very reasonable fair prices, they're not going to charge exorbitant prices. But if there is no other competitor allowed, if there is no other competitor in the market, then what will be the scenario? Whatever the price will be fixed by the person, we will be bound by that price, and we will be doing that, and we have to adhere to that. So if we talk about what was not allowed at the time during the COVID-19 at the time, then we can see that there was this disproportionate and unnecessary concerns of the COVID-19 which has come across with leading to price fixing, leading to allocation of the prices, formation of the cartels. These were certain activities which were restricted. Now nobody is allowed to form a cartel, or nobody is allowed to go for a price fixing. That means they two three competitors will be there and they'll fix a definite price that below that we are not going to sell the price. So these kind of activities were really prohibited. These activities were already prohibited in the normal times, and in the unusual times of coronavirus pandemic, these activities were still prohibited. So we have seen that yes, the competitors, the Competition Act, and the COVID-19 and the role of the commission had a very significant role during this time also. So they have not just issued the advisory once, they had tried to issue the advisories the number of times. So I had already stated in my statements that yes, the 30th of March advisory which was issued, then on 19th of April it was issued, before that on 14th of April was issued. So time and again they had issued the advisory with regards to how the process of Competition Act will be regularized, how this mechanism of competition will be taken into consideration, not only in India but in all the other nations, such as we have talked about the US, we have talked about the European Union. They all have focused that in these times also their primary focus will not get deviated. The primary focus of these kind of law is to maintain the equilibrium in the economy, to see, to check the activities, that they are not going against the activities, they are not going to cause appreciable adverse effect on any kind of competition. So the Competition Commission of India has tried to play a very flexible role time and again, and the analysis will again differ from case to case. It is not just in this one particular case that it will differ, but according to the situation, according to the hardship, according to the peculiarities that has come across, they need to adjust to the environment and they need to adjust to their roles. Now, if we talk about the relief, what were granted. Now, certain reliefs were given to the sectors like the pharmaceutical sectors, that in very negligence amount what were given, but strictly no relief was provided in sectors supposedly where people were involved into black marketing, where people were involved into the hoarding of the commodities, where people were trying to fix a price for the commodity apart from whatever has been given by the market price. So in these situations, the Competition Commission of India has played a very important role at that point of time, and also they had tried to regulate the market structure at that point of time. Now, if we talk about the revival, whatever has happened to Indian economy, and because of that, the Sensex, and because of that, the other activities of India has faced devastating, catastrophic. Like we can talk about that. Yes, they have faced the wrath of COVID-19. Now, it will take a lot of time for the Indian economy to get back to terms. What could be beneficial? That yes, FDI, that is the foreign direct investment, is encouraged, so that they will have a market role, they will have a dominance in the, they will have certain footing in the market, so that the economic revival can be done. Now, if we talk about the measures which could have taken, the supply chains, the permissions which were given to the supply chains were important. Now, disruptions of the supply chain has caused very much damage to the economy, because at that point of time, one thing was being available at a particular place, but that particular thing was not available at some other places. So there, the distribution chain, the supply chain was completely disrupted. But yet again, they had tried to maintain the equilibrium, they had tried to maintain the balance. How and when they used to do so? So any kind of anti-competitive or the horizontal agreement or any kind of anti-competitive association needs to be checked by the Competition Commission of India. This is the advisory, this is the what we can say, the role that the CCI plays. And competition has always been a strict imposer of penalty, not just in rupees, not just in thousand, but in sometimes in crores also, because they are going to charge the penalty not for a particular year, but for the times when such kind of thing was in existence, and for how many years it was in existence. So it is always said that the CCI gives a very stronger amount of penalty, and when the commission gives penalty, they also comes with the compensation mechanism. So they used to charge very huge amount. So in order that everything is regulated time and again, the commission has tried to regulate it by giving it a kind of normalcy. Now, the urgent matters at the time of the pandemic was to be seen that they were heard, and all the proceedings were suspended. The CCI has suspended with regards to the with regards to this COVID-19. The Competition Commission of India has suspended all the filings, whatever filings was to be done before the commission after the lockdown until the 31st of March. If we go through the facts, whatever has been provided over the sites of the CCI, up until 31st of March, every filing was suspended. Now, after that, certain proceedings were allowed that required some urgency. Only urgent matters were allowed, and then decided that yes, after the April, from the month of April 2020 or May 2020, a very minute shift in the normalcy was seen in the work of the Competition Commission of India. But during these times also, there was no change at all in the standard of the competition compliance. That does not mean that the Competition Commission will allow for any kind of merger without the prior permission, or they will allow any kind of adverse effect having, they will allow any kind of competition which will have the adverse effect. No, the standard will be maintained. The only thing is that the standard will be maintained, but yes, the urgent filings of the cases were seen, other things were suspended, no other clauses were changed in these times also. So any situation which stands with regards to the imposition, with regards to whatever the conduct of the firm is, if they are anti-competitive, then they were to be given the penalty. So this is all that the Competition Commission has done with regards to the scenario of the COVID-19. Yet there's a lot much thing that needs to be done. Now, compliance is one thing that requires much attention to it, because the rules are laid down, guidelines have been given, whatever date I had mentioned, these have been promoted, but compliance part is one thing that needs to be strictly followed, because if they are not complied to, then these advisories are of no use. So this compliance part, this filing and compliance part needs to have the implication and needs to see that how this compliance can be done. Now if we talk about the what kind of things were given importance at the time of COVID-19, then the essential commodities, the supply units, they were seen, they were regulated, and Competition Commission of India, along with the Government of India, along with the Supreme Court, had at times given very urgent matters were heard, and very important decisions were taken at that point of time also. And because it is the function of the commission to have to perform the function of watchdog, so time and again they had made the announcement, time and again they had given us the that yes, even though this is the unusual times, but there because of these are the temporary times, these are not going to stay with us forever. And they had undertaken that yes, the enterprises that they are trying to file for the cases, or they're trying those who are not going to file with regards to whatever the merger acquisition they are going to do as per the act that has been provided, then there will be heavy imposition of the penalty. So the Competition Act in itself provides for the penalty clauses, and those penalties can be levied upon any of the companies, any of the association, any of the enterprises or the firms which are not going to adhere to. Now if we talk about certain suggestions, what could have been the suggestions with regards to this? uh, at the time, in the time of crisis, in the time of COVID-19, we have come across that um, uh, the scenario where which was very new to us. We were not open to this kind of situation, but we were forced to live inside our houses, we were forced to live indoors. But yet the measures or the suggestions that could have been implemented at that point of time is that collaboration of open mergers and acquisitions, and the regime to attract the foreign investment and technology. That means in order to revive the economy, we need to have this investment. Now there is a technological advancement, and India is not an exception to this technological advancement. And in the faces of the competition, India is never at a back position in, or we can say has never had a setback towards the technological aspect. So in this evolving times, in these times where the rampant use of internet and e-technologies and various other platforms have been used, now certain investments, if properly channelized, if properly made with the guidance and with all other measures, if it is made, it will be a boon for the boosting of the economy. It will play as a very significant role of the economy. And whatever guidelines were issued, they need to be adhered to, they need to be given importance at the time when they were issued. And the adherence part has to be seen into, has to be taken into consideration. What all things need to be adhered to has yet been provided in the regulations. There must be careful trading of the failing firms, whoever or the firms which were not so developing, and if they had the tendency of loosening their shares, if they had if they were in a position to lose up, at that point of time also the regulations should have been provided that yes, these failing firms had to be taken into consideration with regards to the aspect of how they could be standardized, how they could be given an upper criteria and upper ratio. And the price tracking mechanism, because the whenever there is such kind of situation, people usually try to make advantage out of the situation. And if there are the price making mechanisms, the competition commission should have very vigilant rules with regards to yes, that they are going to have this check upon the authorities, upon the agencies, upon the distribution, supply and the other chains, that they are not going to change the pricing. Whatever the actual price has been fixed, they should adhere to those prices. Then the guidelines on what the modalities of the collaborations will be. They should have been the tolerable modalities. What kind of modalities would have been provided at that point of time? That was a question. So we had seen that yes, at that point of time also certain lenient approach was given by the Competition Commission of India. But when we talk about this lenient approach, that does not mean that they had allowed for any kind of merger, any kind of acquisition, or any kind of collaboration. Only collaboration that would have been beneficial if they are going for the research and development, if they are going for the research and development in the field of the coronavirus, if they are going for the how to vaccine will be made, if the company or the enterprise is going to invest a lot of money in that particular aspect, only then certain things were allowed. But if they are going to have again the negative impact, if they're going to again have a adverse effect on the Indian scenario or the competition, then those will again have to be looked out after by the commission. Then the old cartels, the mandis which are there, they do not die easily. So more vigilance is required. That means we had seen a recent example how the prices of the onion rose to the skyrocketing prices. Now, because this was not any intervention by any other external forces, these were the producers themselves, the farmers themselves, the persons, those who had the link ups in the mandis. Again, these mandi walas had the link up with the producers or with the sellers over there. So in order, they had just formed an informal cartel among themselves, which was again needed to be checked. Now in this situation also, where the COVID-19 scenario, where this kind of situations were seen. So one more thing which was required was that vigilance. That means the commission should very actively, proactive, rather I would use the term proactively, they should use the uh, ability to check, to cross check, and to maintain the balance between the equilibrium, because the only function of this commission is that they need to have a maintenance of the balance between the cautious use of a particular thing and the proactiveness or the market activeness of this scenario. So these would be implemented, this could have been implemented with the due process of time. So this was the total scenario of the COVID-19, of the pandemic situation, and how this competition law, not only of India, but of the various other countries such as China, European Union, Germany, Spain, and UK and USA, they had time and again brought out the various guidelines that were required. Everybody had faced the wrath, everybody had seen that yes, the work from home culture has evolved, and everybody had tried that yes, e-filing, electronic filing, use of the technology should be emphasized. Sashwat, is there anything that somebody could address with regards to questions?
Actually, I had a question of mine.
Yeah, Sashwat.
So, a lot of information has been given by you, and I think, and I'm a quite myself a competition law enthusiast. So,
Mhm.
the this was a scenario in UK where there were some relaxations allowed by the CCI of UK, so that
Yes.
the competitors in the market could collaborate, and till the time the emergency continues, they could operate without being any restrictions given by the CCI. So, do you think that some relaxations like this kind of could have been
No,
yeah, and do you
yes,
think
yeah, in UK also the competition markets or the competition markets had allowed that yes, certain kind of relaxation should be allowed. Now why the certain kind of relaxation was allowed? In order to share the data with each other at the level of stock, at the level of cooperation, at the level of share distribution, at the level of other important areas. Now why such relaxations were given? These relaxations were given in order that in these times, in this crisis, in these times where normalcy was not possible to be resorted, some thing could have been relaxed, certain relaxations was provided. So not only this UK, the US Federation of the Trade, that is that we call, that is known as FTC, the Federal Trade Commission, they have also given temporary relaxation, they have also given temporary relaxation to the modules, to the units, that yes, whatever benefit can be taken, let them take the benefit. But the balance between the allowed thing or the permission which has been granted has to be maintained, rather than taking into the disadvantage proportion. That means if we talk about from the point of view of the relaxations imposed, or the relaxations which were given and the restrictions imposed, these two things, they go hand in hand. That means we cannot take the disadvantage. Even if certain permissions have been allowed, if even if certain relaxations have been allowed to us, that should have been with regards that yes, you are working within the ambit, you are working within the ambit of the scope that has been given to you. So you have talked about the United Kingdom, and in the United Kingdom the market authorities had given a very temporary relief to the elements. They had essentially allowed that they need to give the data sharing, they need to go for whatever kind of information at the stock levels, or the corporations, or the level of distribution in the depots. They were allowed to give the data, they were allowed to go for allowing the data to be shared with the other competitors. But again, competition act, again the CCI rules, they need to focus upon the things that yes, the balance between the economy, the balance between the act, the balance between the process of competition should never get harmed.
Okay, sir. Another question of mine, sir. So if a law student has to prepare from beforehand for a career in competition law, how can he do that?
Sashwat, if a student is interested in this competition act,
Sir,
and
because what
yeah,
happens is that not many colleges taught about competition law, and
right, right,
it's
right.
mostly after practice, the students come into practice, they get to know about competition law.
Right, right, right. So, this Competition Act is never given an importance in the law subject also,
Yeah.
because just a part of eighth or ninth semester is dedicated to one particular law. But there's a lot much of discussion that can be done with regards to competition law, and this is an area of commercial arbitration also, commercial arena also. So most of the part is not discussed in the institutes, but we should see that students, those who are having the interest in this area of competition law or the arbitration or the commercial aspect, certain things can be done. And I had also recommended one such thing in my university, in my college also, that certain streams should be allowed. That if the particular student is interested in a particular stream, say after third year or fourth year, when you actually understand what law is, because first year is you are introduced to the scenario of law, second year you get to know that yes, this is too much and we need to grab all things. In the third year is the time where students think of choosing whether they are going for civil, whether they are going for criminal. Only these two choices have been provided in almost all the institutes, or some constitutional laws are there, certain corporate laws are there, but this commercial law is never given an option. So I would recommend that yes, this commercial field and arena should be provided, and students, those who are interested, they can go for various courses. And I hope this 𝗖𝗎𝗃 has also made a entire syllabus out of the commercial laws, how they're going to implement it, and students should take such kind of courses during their 5 years integrated course, because that will really be helpful, whether these are the seminars or the webinars or organized by your institute, 𝗖𝗎𝗃, and whatever the channel, whatever the syllabus they had tried to incorporate, the student should definitely take up some courses, short courses with regards to the commercial law, which will definitely emphasis. Because when we go out to the area of corporate laws, when we go out to the commercial laws, in all the sectors, in all these spheres, competition law is one major thing that will be seen. But in the practice, in the time of college, it is not given that
Mm.
importance, the in respect to other subjects. Like everybody is running with IPC, CRPC, CPC and other subjects, but this subject is not given that emphasis. But I think that this should also had been given this equal importance with when we are talking about this, because all the big firms that we are talking about, they are focusing upon the how these merger acquisitions are taking, how these regulations are being done. So Competition Act itself is a very, not so huge act, but a very limited act, but it has various provisions which needs very intricate details and detailing with regards to that.
So, do you think that MA lawyers should have a idea or a little knowledge about the competition law
Yes,
area.
every lawyer should have a knowledge about this. I am fortunate enough that I am teaching this competition law and other commercial laws in my university, in 𝗖𝗎 University. But apart from that, every lawyer must have at least the basics. That means section 3, 4, 5, 6 are the fundamentals to the Competition Act. Section 3 is talking about prohibition of anti-competitive agreement. Then section 5 and 6 are talking about the dominance and the abuse in the market and the combination, merger, regulation. These things at least they should have a basic fundamental knowledge and clarity, because whenever they will be going to, or if a client is going to come to them about any suggestion with regards to whatever thing they are facing or problem they are facing, along with the company law, along with other commercial laws, this law, the knowledge of this law is very much important. Because if competition laws knowledge is not enough, or they don't have the basic at least with them, they will never give a correct advice. They will not be in a position to give a correct advice. So I would suggest that yes, every one of us should at least have this commercial knowledge with us, in regards to the contract, in regards to commercial laws, in regards to the competition law also.
So I think, sir, that was a lot of information today, and I think I have to revisit this video once more to get the knowledge, all the knowledge compacted in it.
Thank you to you, and thank you to 𝗖𝗎 platform who has given me this opportunity. And I would really recommend this 𝗖𝗎 to my students also at any point of time. And I would love that if you update me with future events, so that I could share these among my along with my students and other faculty members also. I genuinely thank you, Shashwat, and the team of 𝗖𝗎 who has organized this webinar and had given me this opportunity to discuss this. Thank you so much. Thank you so much for this.
Thank you so much, sir, for taking out your time and joining us today. And I hope to have you around.
Welcome, Shashwat.
Thank you,
Welcome.
sir.
Yeah. Should I leave, Shashwat, now?